Welcome to Defending the Windy City with attorney David Drwencke. As the founding partner of DRD Law, David focuses exclusively on criminal defense, bringing strategy, courtroom expertise, and a relentless commitment to protecting the accused. I'm Leanne Lyon, and in this episode, we are digging into Illinois weapons charges, from unlawful use of a weapon to concealed carry confusion. We'll break down what the law really says and how to fight back when prosecutors overreach. This is episode 22, Weapons Charges in Illinois, Separating Fear from Facts. David, what are the most common types of weapon charges you see in Illinois, and what do people often misunderstand about them?
Well, Leanne, thanks for having me again. This is a great topic because I see it so regularly. When it comes to the most common phone calls that my firm receives, weapon offenses are right at the top. It encompasses a lot of different types of offenses. Now, a UUW or unlawful use of a weapon is probably the most common, and then B, one of the most misunderstood, because one of the first questions I'll receive, be it from the actual accused, the potential client, or from their family members, is they weren't using a weapon. Why are they charged with aggravated UUW or just a straight UUW? And we take a pause and say, this is probably one of the more poorly written statutes, and they have amended them just recently so that the entitlement makes a bit more sense. But a UUW at its core is somebody is possessing a firearm, usually somewhere they're not supposed to possess it, or they're not legally allowed to possess it. So it's just having a gun where or when you're not supposed to have a gun.
Okay, so that charge, what does that charge actually mean, and when is it most often filed?
The single most common fact pattern that I run into in my law firm is someone being charged with UUW or some version of it, because there are different grades on it or felony classifications, from a misdemeanor variety to the lowest level felony up to the most serious level felony, largely based on someone's background. There can be other little variables. If it has an extended magazine, if it were to have a laser sight, if it were to be what's known as a ghost gun, or like a 3D printed gun that doesn't have a serial number, it can work its way up to the most serious offenses. But the fact pattern that brings people to my law firm, or to me most commonly, is someone's driving their car. They're pulled over for any of the litany of reasons you can be pulled over for: not wearing a seatbelt, speeding, not coming to a complete stop at a stop sign, running a red light, or get another host of ways that you can be pulled over. And then
Yeah.
an officer will find a basis to then search that individual or the vehicle, and contraband is found. Typically it's a gun, but it can be drugs as well. But that's usually it, because I'll start to predict it during the phone call. It's like, well, let me guess. You were driving, you got pulled over, and they found a gun, and you'll almost actually hear their mouth go agape and go, "Yeah, it's exactly what happened. How did you know that?" It's like,
Mhm.
this is the thousandth time we've seen that basic set of facts at the law firm.
Wow. Well, in Illinois, I know that there are a couple of things. There is the FOID card. There's also a concealed carry license. And how do these affect the legality of possessing a firearm in these different situations?
Absolutely. The key starting point is that they are separate, which would
Mhm.
make sense when you say, well, do you have a FOID and or CCL? And it really should be and, because typically you'll start with FOID. FOID's an acronym for Firearm Identification Card. That's really not a difficult process. You can start it online, you complete some paperwork, and you can be approved or denied. There is a list of requirements that you are to meet about your criminal background, along with mental health background and some drug related background and so forth. And within a month or so, if you meet the criteria, you'll receive your card. You'll get a notice that you've been approved, and then the card will come in the mail. The Illinois State Police, the state's attorney's office, can file their own petition to have you be denied for one reason or another. But the FOID is all about your ability to go and purchase a gun, own a gun, and then possess a gun with very, very strict rules. But that's the first step to having a gun in Illinois, or more specifically in Cook County, Illinois. A CCL, or a concealed carry license, is another step beyond that. That actually requires classroom time. It requires going to a range. There's more involved in it. Usually, if you've had the FOID, you'll be immediately eligible for the CCL. I don't know many people would get a FOID and then be denied the CCL, but you have to meet the basic requirements of doing the classroom work and getting hours in at the range and so forth
Mhm.
before you can apply for it. The CCL opens up the ability that you opened with the FOID card to possess and own into more areas, and how you can carry the gun and how you can transport your gun and so forth. It starts to give a bit more leeway with that. But even with the CCL, it doesn't mean you get to just carry it everywhere and have it fully loaded. And among other things, there's still a great deal of restrictions on gun possession, especially in Cook County, Illinois.
Okay. So, are there some scenarios where somebody could be arrested for a weapons offense even if they believe they were following the law?
Routinely, unfortunately, I'm coming from a court case quite literally today where a client did have a FOID. So the gun that he had purchased was legal. He could transport it. Unfortunately, he wasn't doing that part correctly. And he believed he had a CCL. It was a misunderstanding from his own point of view about what he needed to do and what did it mean that to officially have it. He had gone to the courses, he had completed the paperwork, he had submitted it, paid the relatively nominal fee, and he thought he was done. He said, well, I have the FOID, I've met all the check marks, I filled out the paperwork, I paid my fee, I must have a CCL. He did not, unfortunately. So when he was pulled over for utilizing his phone while driving, officers asked, we see you have a FOID card. Are you
Mm.
possessing your weapon right now? Is it in the car? Are you transporting it? And he was very polite, did everything, largely by the book, and answered the question honestly. And said, yeah, I do. I have it on my hip right now. I have it in a holster. And they ran his name through the database only to find out you do not have a CCL. You are transporting this gun illegally. And he faced, albeit the lowest level felony, but a felony nonetheless, because he wasn't transporting it correctly, even though he had a FOID card. And again, he was very polite and honest with the officers, still was facing a felony charge.
Wow, that's got to be a devastating feeling. And you say you see this quite often.
I do. Again, it's anecdotal, but I've been doing this for so long, and again, being a solely focused on criminal defense now for as long as I have been, you start to predict the calls, and domestic violence and then weapon offenses are if it's not one and two, they're right up there. They're just the most common type of thing that we run into, and because we run into it so often, we know the case law. We know the types of defenses that are out there. We know some of the buzzwords and things that we're looking at for how to attack this type of case, where maybe you did possess the gun illegally, but something was done wrong from the police perspective, as far as like a Fourth Amendment claim, a bad search, or when we get into the nitty gritty of actual possession of a weapon, and then what's known as constructive possession of a weapon, when the easy part of that is not literally on your person. There is a great deal of case law that we can get into the weeds about what makes up knowledge, what is a constructive possession case, and so forth. So not all hope is lost, even when you have a gun on your hip when you're not supposed to. Not that I'm encouraging it, but again, we know the law there where we can protect our clients' rights. And even if they've done something wrong, if the police have done something wrong as well, or the state can't meet their burden on certain elements of specifically a constructive possession case, a client can still walk out of the courtroom with no background whatsoever, being found not guilty or having a case dismissed.
What a relief in those situations, for sure.
Oh, absolutely. And that's, I can think of a number of examples,
Yeah.
one of each type, where we had a client who was just standing outside of a vehicle. The police rolled by, got out of their car, and just ran right up to him effectively, patted him down, and grabbed a gun that he did have on his person. And first blush, you're thinking, well, he has it on his person. This is a wrap. That's even what his family thought. It's like, what do we do? Can we keep him out of jail? He didn't have any background. Can we keep him out of jail? It's like, well, I looked at the video. I think we can do one better than that. I think we can get this case dismissed because police violated the Fourth Amendment. This was an unreasonable search. And we were right. We filed a motion. We did the evidentiary hearing. Case was dismissed. The judge agreed that the police violated his rights. There's another example, again, from a trial about a month ago, where it was my client driving his own vehicle. A gun was recovered underneath his seat. And so the police pretty rightly assumed this must be your gun. We're going to charge you with illegal possession. He did not, or a UUW, didn't have a FOID or a CCL. Well, again, understanding the nuances of Illinois constructive possession law, I looked at the facts. I looked at the police report and I looked at how this gun was recovered. And it isn't that the police did anything wrong. It was a proper stop. It was a proper search. But ultimately, under the, again, the nitty gritty, the nuances of the law, the state couldn't prove he knew it was there. That there are no automatic inferences or assumptions just because it's your car that you automatically know what's underneath your seat. There could be some assumptions there, but it's
Mhm.
not enough. And you get into it. There are all these examples. Did my client make a gesture towards the gun? Are there fingerprints or DNA on the gun? There's a really kind of novel example of a case where somebody was text messaging with someone else about buying a specific type of weapon. Lo and behold, the type of weapon the police recovered. And that was enough to show knowledge. But in my case, there was no move, there was no DNA, latent prints, no text messages, nothing else to point that he had knowledge that that weapon was there. And following a very brief bench trial in front of a judge, finding of not guilty, and he walked back out the front door a free man with no criminal background whatsoever.
Wow. Well, that's a special case I know you've mentioned, but what kind of evidence do prosecutors typically use to support a weapons charge, and how do you attack the state's case in those situations?
Sure, and it goes back to what type it is, and that's always one of my very first questions is, did they find it on you or did they find it near you? Was it an actual possession or a constructive possession? Actual possession cases are the most difficult because if the stop and the search are legal, are constitutional, it's on you. There's no argument about knowledge. It's in your pocket, it's on your waistband, it's on a holster or what have you. It's on you. That is very tough. I also want to make sure, did my client make any statements? Is there any objective testing? That goes back to fingerprints, latent prints, DNA swabs of the gun. If they're alleging perhaps the gun had been fired earlier in the day, or that's why police were arriving on the scene because they had heard that a weapon had been fired. Well, are there gunshot residue tests, or we'll abbreviate GSR? Do they have those? Is there some other independent information there to tie this to my client? Actual possession, again, being more difficult, where we really are getting into the nitty gritty of the case itself. Is this a proper stop of the vehicle or my client? And is this a proper search of the vehicle or my client? When it's constructive possession, still, we need to know all the details. Where was it found? Did you make a statement? Do they have those objective findings again, latent prints, DNA, GSR? Do they have any of those things? And if they don't have some of the stuff we talked about earlier, a movement, what formally would be called a furtive gesture, where it appears somebody was moving in the direction of where the weapon was found as if to be concealing it. Was there a movement there? Do they have the objective DNA, fingerprints, GSR? Did my client make a statement? Because again, plenty of examples where I'm listening along going, this is constructive possession, we can win this, this is defendable, we're going on. And then, oh, they made a post Miranda statement admitting that they knew the gun was underneath the seat or in
Uh,
the glove compartment. And then what becomes an imminently, I mean, outright likely trial victory, maybe at a motion as well, immediately goes away. It's like, well,
mhm.
there are no longer trial issues for us. We are going to need to negotiate in that situation, unfortunately. But that's what I'm looking for, are those types of things. And there's subtle differences, but understanding the case law is so crucial, because from the initial consult, truthfully, if the client or the loved one gives all the details as they know them, they're honest during that consultation, and that bears out being true what they share with me, I know immediately if this is a defendable case or not. Now, if somebody
Mhm.
doesn't necessarily know the details, or maybe they are less than truthful in everything they share, well, then we wait to get police reports, and then the absolutely crucial body camera, as that shows us exactly what happened and what things were said either by my client or an officer on the scene.
Well, that brings up another interesting thought. What do recent shifts in public policy or political pressure around gun violence, how does that affect the way these cases are prosecuted? Has it changed lately?
It has. There's been a very significant change from the old lead state's attorney, Kim Fox, to now Colleen O'Neill Burke. And that has been one of state's attorney O'Neill Burke. Her one of the biggest things, her bugaboo is guns. And of course, violent crime, among other things, but guns in particular. And I am aware that inside the Cook County State's Attorney's Office, they now have new marching orders about how are they to handle gun cases? What autonomy do they have in making offers or reducing from one version of a gun offense to another version of a gun offense, or whether they'll offer some of the special programs that are, assuming you meet certain criteria, certain clients could be avail themselves to. And it's changed drastically, where in the past there was a lot of autonomy, there was a lot of flexibility to look at a situation and say, listen, it's a possession offense, albeit of a gun, so we don't want to make light of it, but on its face it is a possession offense. It's not a violent offense, though you're possessing something that certainly could be used for violence. And a lot of states attorneys, not that they didn't want to take it seriously, look at somebody, it's their first gun, maybe it's their first offense. Of course, it went as a matter of as an assumption that you could get first-time weapon offender probation, or that avoiding prison time was almost taken for granted. Under the new administration, a lot of the state's attorneys in these rooms don't have the autonomy to just automatically make those offers, so cases go on a little bit longer. And because they don't have the flexibility of making what I perceive as being good offers clients should be very interested in, like first-time weapon offender probation, or like a misdemeanor reduction from a felony, or getting probation, that those no longer on the table. More cases are going to trial now, even when the facts aren't great, because there's very little reason not to. If you're not giving somebody a reason to give up their trial rights, and the offer is effectively what they would get after losing trial, roll the dice. Why not do that? And we're finding an awful lot of clients are doing just that. Though in for my practice, being a bit of an over explainer and showing the work, we do still get excellent results because we can put together the right mitigation, and because we have a reputation for knowing how to handle these cases. We don't have clients accepting bad offers when they certainly have a very good chance of winning at trial, or if they don't, they know that we're coming to this type of case with an expertise and saying, you do not want to go to trial. Let's work out the best deal. And here's why, because we can show you the work. We've earned the trust, and they understand not to go to trial, even when the offer may not be exactly what they want.
Well, you've definitely demonstrated your expertise in this area. So, as we wrap up today's episode, can you share a story where your defense work made the difference in a weapons case, whether it was a dismissal, a reduction, or an acquittal?
There's a number of them. In fact, again, it's always so timely, and we handle so many of them, that there is a type of weapons offense. We call it armed violence in Illinois. And again, it's another one of the more poorly named violations that you can have, or a type of crime that you can pick up. In a nutshell, is you had guns plus drugs, or gun plus drugs is maybe the most overly simplified version of it. And unfortunately, a very young man, 19 years old, no criminal, no juvenile background, no adult background, but unfortunately he had some cannabis, he had a scale, and he had a gun. So this went from what would have been a very low level, maybe a misdemeanor, maybe the low level felony version of a gun possession, all the way up to a class X version with a minimum of 15 years in prison. That's what he was looking at, because he had the wrong combination of stuff, again, guns plus drugs. And fortunately, again, leveraging a relationship, be it with the state's attorney and the judge and so forth, him being his own best advocate as well, because he was able to put together, with our help, great mitigation. He was an excellent student. He had no criminal background. He had great plans for the future. It secured a job. He had a lot of community support, family support, and these were all things that we could then bring to the state's attorney, and then later to the judge herself at what's called a 402 conference in negotiating. And we went from that class X version minimum of 15 years to a 2-year probation offer, which again, night and day, huge difference in outcome there. And that just occurred over the last 24 hours. And that, again, that comes from knowledge of these types of cases, how to defend them. But then at the core of it, relationships, mitigation, and being able to negotiate as well.
Wow. Is there anything else you'd like to add as we wrap up the episode today?
Sure. I think I've shot some like TikTok videos and shorter things. And the advice is listen, not that I'm advocating people to drive around with guns. Go get your FOID or CCL. Don't do these things. But what I find is that someone is committing some other more serious offense, like possessing a gun they're not supposed to have, or other contraband they're not supposed to have. Yet that isn't really how they get caught. They get caught on smaller things. They don't put on their seatbelt. They're
Mm.
speeding. They go through a red light. So this little thing is something to be a ticket. Something very minor. You're going to leave the scene with having to pay a fine, maybe at worst, or some points on your driver's license. But it's that small thing that then begets the big thing, which is having a gun or having contraband or what have you. It's just why stop letting the small thing beget the big thing. So mind your p's and q's. Be pleasant with the police. Wear your seatbelt. Obey the laws of the street to begin with. But especially if you're doing something you really aren't supposed to be doing, don't let the small thing become the big thing, because I see it each and every day.
Excellent, excellent advice. Well, thank you for joining us on Defending the Windy City with David Drwencke. Weapons charges can carry serious consequences, but they don't have to define your future. If you're facing a gun related offense, talk to an attorney who knows how to challenge the assumptions behind the charge. Visit drdlawllc.com to connect with David. And don't forget to like, subscribe, and leave a review. Thank you, David.
Thank you.